Hello, welcome back to my channel again. It's your favorite lawyer. So today we are going to continue with the third part of our family law series. In the first part, we talked about prenuptial agreements. In the second part, we talked about court marriages. And now in this third part, we're going to be talking about divorces in Nigeria. As I mentioned in the video before this, when we talked about court marriages, I made it clear that there are three forms of marriages that are acceptable in Nigeria. The three of them are valid, and these three forms of marriages are the court marriage, as is popularly called, or which is rightly referred to as a statutory marriage. Then we have customary marriages, which are popularly known as traditional weddings. Then the third form of valid marriage in Nigeria is the Islamic marriage. So divorce in Nigeria is done based on these forms of marriages. So the divorce under an Islamic marriage will be conducted in accordance with the Islamic provisions for divorce. A divorce under the customary marriages will be done in accordance with the provisions in the customary law, in the customs and traditions. And then the divorce under the statutory marriage is done in accordance with the provisions of the Matrimonial Causes Act, which supplements the Marriage Act of 1914. So for the purposes of this video, we'll be talking specifically about divorce with respect to statutory marriages. And so we are going to be looking largely at the provisions of the Matrimonial Causes Act, MCA. It's also important at this point to acknowledge the fact that the procedure for divorce under the MCA is quite robust. And this is unlike divorce under Islamic law or customary marriages. Again, like I referred to in the video before this, when we talked about court marriages, it is one of the benefits of court marriages, or it can also be a disadvantage depending on which side of the pendulum you're on. So while for customary marriages that usually you can end just by returning the bride price without any much ceremony, that is basically the procedure under customary marriages and Islamic marriages. But for statutory marriages, the procedure is very robust, it's very complex and complicated, and that is what we'll be delving into in this video. So section 15 of the MCA, the Matrimonial Causes Act, states that there's only one ground under which a marriage can be dissolved, and that ground is that the marriage has broken down irretrievably. It means it has broken down beyond repair. It cannot be retrieved, it cannot be fixed. This is the sole ground on which one can bring up a petition to a court of law for divorce. So at this point, I would like to state what I also referred to in the second part video when we talked about court marriages, that under the Act, a statutory marriage can only be dissolved by a court of law in Nigeria. So one myth that will be busting in this video today is that, unlike in some Western countries where people can just sign an agreement and go their separate ways, the marriage will end. In Nigeria currently, that does not apply. It is common to see in our Nigerian movies and films that people signed papers of divorce. This is false in Nigeria currently, because you cannot end your statutory marriage by signing papers of divorce. Because for you to get a certificate of divorce in Nigeria, it can only be issued by a high court in Nigeria. The court will first consider and ensure that it establishes all it's supposed to be established based on the provisions of the MCA. So this means that where one party wants a marriage to be dissolved, he or she has to file a petition before a high court in Nigeria and any of the states in Nigeria. The person that will file this petition is referred to as the petitioner, while the other party is the respondent. One bonus point I can also give at this point is that for purposes of dissolution of marriage, the entire Nigerian Federation is considered as one jurisdiction. By this, I mean that you can file your petition for the dissolution of your marriage in any state, whether you're resident there or not. Although the action can actually be transferred if the judge feels that it will be fairer and more equitable to get the matter transferred and there's no objection. It can subsequently be transferred to another state. But it's important to note that you can file your petition for a dissolution of your marriage in any high court in Nigeria. So the divorce proceedings has to be instituted by the petitioner in a high court. And when this matter is instituted in a high court, there are other factors that have to be considered. Like I said earlier, the only ground for which a marriage can be dissolved is that the marriage has broken down irretrievably. However, the same section 15 of the MCA that provides for the sole ground for which a marriage can be dissolved also now provides for the factors that can contribute to that ground. So you will note that a marriage cannot be dissolved just because of any factor, but the factors have to translate into being that the marriage has broken down irretrievably. That's the sole ground. But then it's now the factors, that's things that you can use to establish that ground. And those factors include failure to consummate the marriage. And consummation of marriage as envisaged by the act means the first time that the parties will have sex. Where there's a failure of consummation of marriage is a factor that can lead to the marriage being broken down irretrievably. Then where you have that one party deserted the other, it is a factor that can lead to the marriage being broken down irretrievably. That same section also provides if the parties have been separated for at least 2 years, and if it's 2 years separation, then the consent of the respondent will have to be sought. But if they be separated for 3 years, the consent of the respondent is not required. Recall that I said that the other party, the person that files the petition, is the petitioner, while the other party is the respondent. So it is assumed that the respondent still needs to agree that the marriage can be dissolved if it's just 2 years that they have stayed apart. But once it is 3 years, the consent of the respondent is not required. Those are factors that can translate into meaning that the marriage has broken down irretrievably. Now, the act further explained what it means that you don't live with your spouse for those 2 years, that you've been separated with your spouse for those 2 years. As long as they are not staying on the same roof, then it means that they have been separated. Because you see some instances where the couple are in the same roof, although they live as strangers, but the act doesn't envisage that scenario as being separated. This is where the issue of living apart comes into play. Another factor that the act has provided that will also lead to that ground of the marriage being broken down irretrievably is if the respondent has committed adultery. Recall that it's the petitioner that has filed the proceedings. So if the respondent committed adultery and the petitioner finds it intolerable to continue to live with the respondent, then that can now be a factor to establish that the marriage has broken down irretrievably. Note that from this, you will see that it is the respondent that committed adultery and the petitioner cannot tolerate it. So if the petitioner tolerates it, condones it, and forgives the respondent, they can go ahead. It is where the petitioner is unable to condone it and manage it, then it can be a ground to establish that the marriage has broken down irretrievably. Then another factor that the act explained in details is where the actions of the respondent is intolerable, and such acts of the respondent include where the respondent is involved in bestiality, that is sleeping with animals, where the respondent is involved in cruelty, abuse, or where the respondent is involved in intoxication. That is an alcoholic that gets drunk and is largely intoxicated and is unaware of his or her actions. So such extreme conditions are explained as intolerable behaviors. Those are behaviors that the petitioner cannot tolerate. Another form of intolerable behavior, which has been determined by the courts in some case laws, these are not explained in detail in the act, but by case law they have been explained, is constructive desertion. Now, we've talked about desertion where one party abandoned the other party, right? But in this case, the abandonment is seen as being constructive because it is not the explicit type of abandonment where one just deserted the other party and left. In the same way, the courts have established constructive desertion. And this is a case where one party, in this case the respondent, has denied the petitioner repeatedly for a long time of conjugal obligations, which specifically relates to having sex. So if there's a long chain of denial for a very long time subsequent to the initial one, which has consummated the marriage, it is seen as constructive desertion. If you can establish this in court, then it is also a factor to prove that the marriage has broken down irretrievably. Finally, another factor that can be considered to establish the ground of the irretrievable breakdown of the marriage is where a spouse, and in this case it will be the respondent has been missing and is presumed to be dead. So if a spouse has been missing for at least 7 years and is presumed to be dead, it can be a factor upon which the petitioner can state that the marriage has broken down irretrievably, and then the petitioner can seek for a dissolution of the marriage based on that scenario. At this point, it's important to know that there are different kinds of reliefs that can be obtained in a court with respect to matrimonial causes. So you can ask the court for a restoration of conjugal rights. If the conjugal rights have been denied, you can go to court and request for a restoration of conjugal rights. And where the respondent does not comply, it means the party is in contempt of the court, right? And it's a criminal offense. Contempt is a criminal offense. But in this case, since it has to do with conjugal rights, and the respondent is not willing to still give the conjugal rights, that can now be a ground to now seek for a dissolution of the marriage. So as opposed to charging the person for contempt, that can now be a ground to a request for a dissolution of the marriage. Based on this topic, this video specifically relates to the decree of a dissolution or annulment. And I'd like to distinguish at this point between both concepts. So annulment, as the name implies, means that the court is just going to order that the marriage was void from the beginning. It was invalid. So there are two concepts, void and voidable. So when a marriage is void, it means that from the beginning, ab initio, provisions of the Marriage Act and Matrimonial Causes Act were not followed, and those factors made the marriage illegal. For the purposes of clarity, I will state that some of these factors were considered in the second part video. We talked about the requirements for a valid court marriage, for you to have a statutory marriage. The requirements for the validity, that's with respect to the age. So if the person is underage and there's no consent, it means that marriage is void. If the petitioner brings up a petition, it can be voided based on that. The marriage can also be voided if it was found that there was a misrepresentation. Like I explained this too in that second part video. So if there's a misrepresentation on the part of the respondent misrepresented him or herself to the petitioner, and there was a mistaken identity. Based on that, the petitioner married the respondent and then found out. It means the marriage was void ab initio. In the same way, if consent was also obtained by fraud or obtained by duress, it's also a factor to make the marriage void. Another instance, again, which I also stated in the video before when we talked about court marriages, is if one of the parties was already married before without the knowledge of the other party. So in this case, if the petitioner finds out after they've gotten married that the respondent was married before, either under the customs or under Islamic law or under another statutory marriage, it means that the marriage that they have contracted is void. Another instance is if the petitioner finds out for any reason that there's any close affinity or consanguinity between the petitioner and the respondent. So it's another factor that makes the marriage void. Or based on any of these factors, the marriage is void. And what the court will order in that instance is an annulment of the marriage, because the marriage did not even exist in the eyes of the law. The other aspect is now the dissolution of the marriage. In this case, it means there was a marriage that was contracted, but for any of these reasons, so you now approach the court. What the court will grant in that instance is a dissolution of the marriage. In this case, the court will dissolve the marriage that was validly created. So you can see on one hand, the court is saying that this marriage did not even exist and is annulled. But in this case, the court is now dissolving a valid marriage. Now we'll look at what the court will consider before it grants that order of a dissolution of the marriage. So in divorce proceedings, the court will consider children. So if there are children in a marriage, It's one factor that the court will consider. Primarily, the court considers welfare of children. It is very paramount in determining the dissolution of a marriage. So the court will determine who takes custody of the children. When we refer to children, we're talking about children that are not up to 18 years. So they are seen as children in the eyes of the law. The court will determine maintenance. Then the court also determine the procedures with respect to the visitation by the other party, usually the man. At this point, I'll state that the issue of custody is another whole topic that we'll talk about. Is also this part of this series. So the court will look at the children, and that's one of the factors that the court considers in divorce proceedings. The second factor that the court will consider in divorce proceedings has to do with property and assets that belong to the couple. So the court will also determine how the property and assets will be shared, taking into cognizance the properties and assets that were acquired by the parties before marriage and during the marriage, and the court will try to be equitable based on what the persons had, particularly before the marriage, and the conditions on which they obtained those properties even during the marriage. That's where the issue of spousal maintenance comes in. And then the court also is interested in reconciliations. So the Matrimonial Causes Act even provides for interventions by the court. The court should allow interventions and reconciliatory intervention. The courts are also enjoined to ensure that they can try to reconcile the parties as much as is possible. So when a court has made all these considerations and has catered for everyone as much as possible, particularly with respect to the children and with respect to property and assets management, sharing and splitting. So when the court has put all this into consideration and the court has also considered reconciliatory moves but has failed, then the court can now grant an order dissolving the marriage. And that first order that the court grants is called an order nisi. The court grants that order dissolving the marriage, but it's an order nisi because it's temporal, as the court allows the parties further time to see if they can still reconcile within that period. Please note that at this point, the parties are still married because it's not the final order. It's not the final dissolution order. In fact, you are still married even while the proceedings are on before the order nisi is granted. So you cannot still go ahead to contract another marriage whilst this marriage is still pending. And so within that time that the order nisi is granted, parties may still reconcile and can go back to court and their marriage is still valid. But if parties don't reconcile at that point, then and the time elapses, they will now still go back to the court and the court will now issue a decree absolute. And that is the final decree dissolving the marriage, because that is referred to as the decree absolute. It's upon that you have now been legally divorced. So you can see that from all of this, the initial means that we bust at the beginning of this video, that you cannot end your marriage by signing divorce papers, because it's only upon the final dissolution order by the court that your marriage is deemed ended. So in conclusion, you will observe that divorce proceedings in Nigeria are lengthy and could be stressful. And this is why you need the services of a legal practitioner throughout the proceedings, so that you can ensure that you have gone through the process in accordance with the eyes of the law and you don't get stuck midway by being turned back if you do not follow the process that has been laid down by law. But the comfort that one has is that divorce proceedings for statutory marriages are well detailed and have proper and clearly spelled out procedures that one has to follow. Cater for the welfare of the children and cater for assets sharing, and it caters for all parties involved to ensure that everybody's rights are properly taken care of. So this is where we'll be drawing the curtain for this video. And like I said, we'll talk about custody and we'll talk about maintenance. Also talk about judicial separation. I hope you got value from this video. Kindly comment or ask your questions in the comment section below. Please also do well to like the video again, and please subscribe to the channel so that I can get updates of future videos that will be uploading. Thank you for listening up to this point, and I really hope you got value from this video. So I'll see you in my next video. Bye.